Good morning, everyone. We're just going to give it 2 minutes to allow everyone to join, and then we'll kick off. Good morning, everyone, and welcome to the Employment Law Update. This is our last Employment Law Update for the year. And as usual, we have some cases, 11 in total today, impacting the employment law landscape in South Africa to share with you. My name is Helen Wilsonach, and I'll be facilitating this morning's update. I'm joined by my colleagues in our employment and benefits practice, whom I'll introduce as we get to the cases that they'll be presenting. If you're a regular attendee of law updates, most of them I think will be very familiar faces to you. Before we begin, I would just like to run through a few housekeeping matters which will enhance this webinar experience for you. As participants, you are automatically muted and the chat functionality has been disabled. If questions during the webinar, please can you just make use of the Q&A tab at the bottom of your screen. They'll be submitted to me and we'll try and get you as many of them as we can. We will also, please note that we won't be providing written responses to any questions, but the webinar is being recorded and a copy will be available on our website, www.bowmanslaw.com. In addition, we'll be sending you a high-level summary of the cases discussed this morning with the key takeaway legal principles highlighted, and these should be sent to you early next week. So without further delay, welcome and let's begin. Our first three cases today all deal with retreat. Our first one is Roz is going to take us through a partner in our employment practice who I think is a very, very familiar face to everyone. This is a more of a technical case and deals with where the required dispute referral process after facilitated consultation process. Roz.
Thanks, Helen. Good morning, everyone. So I'm going to try and go through this one quite quickly. It involves the question of whether or not there is a need for a union or employees to refer a dispute to conciliation following a dismissal where there has been a facilitation process in terms of Section 189 capital A. So broadly speaking, the facts of this case are that SAA Technical embarked on a mass retrenchment. Because of the number of employees involved, it was a 189 capital A retrenchment process, and they elected to go to facilitation and to use the services of the CCMA instead of doing sort of the in-house consultation process. Following the facilitation process, and after the 60-day period, SAA gave notice to terminate the contracts of employment of the union's members. Now, as I'm sure everyone on this call is aware, Section 191 of the LRA deals with disputes about dismissals, and it covers all range of dismissals, including retrenchments. And the requirement in dismissal disputes is that there must be a referral to conciliation, and If conciliation fails, then the employee can elect to go either to the Labour Court or to the CCMA or Bargaining Council, depending on the nature of the dispute. Now, retrenchment disputes ordinarily would go to the Labour Court. Section 189 capital A talks about what happens following a facilitation process if there is a dismissal and then a dispute arises. And this section says that after the 60-day period for facilitation, the employee can give notice of termination, and the employees have an election. They can either embark on strike action, or they can approach the Labour Court for adjudication. And it's this wording that has led to a whole range of controversy on whether or not it's necessary to go to refer a dispute to conciliation where there's already been a facilitation process. Unfortunately, what has happened is in the past there have been conflicting cases, and some Labour Court judgments have said it's not necessary. The Section 189, capital A, says once you've had facilitation, you can elect to go to the Labour Court. It is therefore not necessary to refer a dispute to the Bargaining Council or to the CCMA for conciliation first. In this case, the union, following the facilitation, received the notices of termination, and the union elected to approach the Labour Court directly. SAA raised an in limine point, and they said the Labour Court does not have jurisdiction to entertain this dispute. And the reason for that is, on SAA's case, is that conciliation is a precondition for the Labour Court's jurisdiction. And if there is no conciliation of the dispute, then the matter cannot be adjudicated. Now, the union's case was that there are a number of Labour Court decisions that says specifically following a facilitation process, there is no need to go to conciliation. And the reason for that is probably twofold. Firstly, the Act says that following facilitation and notice of termination, there is an election to either strike or go to the Labour Court. It doesn't say you need to go to the CCMA or Bargaining Council first, or it then, insofar as it references Section 191, that is simply insofar as the 90-day time period is concerned. So that the case authority that they relied on was the authority that said that facilitation was sufficient. Then on that line, the union argued that because of the facilitation process, there was no purpose in going to conciliation before the CCMA. The CCMA had already been involved. They had run the facilitation or facilitated the consultation process. So there was no purpose to be served in going to conciliation. And the SAA, on the other hand, said no. If you read Section 189 capital A together with Section 191, subsection 11, what subsection 11 says is that the referral to the Labour Court must be made 90 days after the dispute has been conciliated. So after there's been this unsuccessful conciliation. So in this case, the Labour Court disagreed with previous Labour Court authority, and the Labour Court said no. Facilitation is something different to consultation. It is not the same, and therefore it is not sufficient to say that there is no need to go to conciliation. And the reason for that, the Labour Court said, is that the facilitation process is a completely different process to conciliation. Facilitation is aimed at ensuring compliance with the Section 189 to ensure that the parties properly engage in a consultation process with a view to reaching consensus on whether or not retrenchments are necessary and all of those other elements that you need to reach consensus on. And that all happens pre-dismissal. Conciliation is something completely different, and conciliation is there once a dismissal has happened, where there is a dispute about the fairness, for the parties to see if they can settle that dispute. So the Labour Court said that insofar as previous judgments had found otherwise, they were wrong, because conciliation is not the same as facilitation. The union then took the dispute on appeal, or took the judgment, sorry, on appeal to the Labour Appeal Court. And the Labour Appeal Court, or the union's argument was the same, and they said that the previous Labour Court decisions that had found that conciliation was not a necessary prerequisite for the Labour Court's jurisdiction were binding, and they constituted legal precedent, and therefore they needed to be followed. Now, the Labour Appeal Court considered this and said, look, we're a court of appeal. We are not bound by previous judgments of the Labour Court. Now, that's a pretty trite fact. Another element that the union relied on was the EDCON judgment. Now, the EDCON decision, which went to the Constitutional Court, contained a opinion, I suppose would be the right way to describe it, an opinion in terms of which they seem to suggest that conciliation was not necessary where there was a facilitation process. The Labour Appeal Court considered this and said, we are not bound by that because it was obiter. It was not a legal precedent, and that is not what the basis of their finding or the case that they were looking at concerned. So the Labour Appeal Court said, we're not bound by the previous decisions. We need to look at the purpose of the LRA firstly. Now, one of the primary purposes of the LRA is to try and effectively resolve employment disputes, dismissal disputes expeditiously. And for that reason, conciliation is seen to be crucial to the process, because it's an attempt to get the parties together, to get them talking before a mediator, so that the dispute can be resolved without having to go the next step. So for that reason, the Labour Appeal Court said conciliation is essential. It is necessary. Then they looked at Section 189A, and they said that although 189A does not say that after facilitation, when there's a notice of dismissal, there must be a referral to conciliation, what they did say was there must be a referral to the Labour Court, or there may be a referral to the Labour Court in terms of Section 191, sub 11. Section 191, sub 11 talks about the 90-day period following unsuccessful conciliation. And on that basis, the Labour Appeal Court said it must have been the intention of the legislature that there had to be a conciliation before the matter is referred to the Labour Court. So the Labour Court agreed with, the Labour Appeal Court agreed with the Labour Court's findings in this matter, and has now determined that conciliation is required. It's a prerequisite for a dismissal or mass dismissal following a 189A process, and in the absence of a conciliation and referral to conciliation, the Labour Court does not have jurisdiction to entertain the dispute. So the Labour Appeal Court then dismissed the finding. Okay, Helen, that's that one.
Thanks, Ros. So I think just underlining just how the level of importance is on conciliation, and the fact that it's not just a formality, but something that they see as a very key part of our dispute resolution process. Our next the world of retrenchments is going to look at what constitutes fair and objective selection criteria grounds. Ayanda, Senior Associate in the practice area, after a bit of a break, is going to take us through it. And Ayanda, I know you spend a lot of time in court defending employers in relation to retrenchment disputes, so I'm sure it's a very interesting one for you.
Yeah, thank you very much, Helen. It has been, well, good morning, everybody. It has been a while since I've appeared at this forum. So I'm happy to be here, and I hope all of you are happy to be here too. This is a Labour Appeal Court judgment in the matter between Umicore Catalyst South Africa versus NUMSA on behalf of 5 others. And as Helen pointed out in the introduction, this case concerns the fairness and objectivity of a selection criteria, and effectively how a court is going to handle that evaluation. So the facts take us back to 2015, when the company was embarking on a restructuring process. They had anticipated automation and basically the loss of employees with the introduction of new systems. And so this was a large-scale retrenchment, and it was conducted in terms of Section 189 capital A of the LRA. And more to the point, during the consultation process, which was facilitated by the CCMA, the company decided that the selection criteria that would be applied generally would be last in, first out, LIFO. And I'm sure that many of us are familiar with that principle. However, there was a distinction in respect of one of the departments, and it was the lab. So in deciding on the criteria, what the employer did was to introduce something called a lab assessment. And this was effectively a questionnaire that was designed to try and select the employees who had the best skill. I mean, the rationale for it, I guess if you can call it that, was that they were trying to get people who could operate the lab independently, because it was a role that required them to perform at a high level, irrespective of their position in the lab. And I'll talk you through some of the questions that are asked in the questionnaire when I deal with the Labour Appeal Court judgment. But effectively, the union at the time, which was not NUMSA, they objected to the questionnaire being applied. And this was because it was too subjective. And so what the company decided was that they would introduce, or let me say what they proposed at first, was to introduce certain what they believed to be objective criteria. So included in that was the disciplinary records, their performance appraisals, and their attendance over the past 2 years. And all of these components, being the lab assessment, plus performance appraisals, the disciplinary records, and the attendance records, they would all weigh evenly. So ultimately, the lab assessment was 25% of this overall selection criteria consideration. And the lab assessment was going to be conducted by a panel consisting of 3 people. The first person was Mr. Brits, who was the section head of the lab. He ran the whole thing. And then there were also 2 other department heads from other departments. And ultimately, a group of 4 employees decided that no, they did not want to participate in this questionnaire. And as a consequence of their non-participation, or rather as a consequence of the assessments which were conducted in their absence, those employees were subsequently dismissed. So, of course, the matter went to the Labour Court, and the Labour Court essentially concluded that the dismissals were substantively unfair. But this was on the basis that there was, or the Labour Court found, that there had previously been an agreement between the consulting parties that LIFO, last in, first out principle, would apply, and the company deviated from that agreement. And that was really the basis of the Labour Court's judgment, which is pretty straightforward. But then the matter was referred to the LAC. And what the LAC concluded was that the Labour Court was wrong because there was only a proposal on the issue of the lab assessment, and even LIFO had not really been agreed upon between the parties. And really where the parties had left it was that there was the proposal for the lab assessment, and even though the union disagreed, the employer pressed on, which of course in and of itself is not necessarily problematic in terms of our legislative framework. So the issue before the LAC remained the same, and that was whether the selection criteria that had been applied to the lab was indeed fair and objective. And ultimately, the LAC held that this was not the case. And really the reasoning was two-parted. So, I mean, beginning with the relevant principles, the court didn't need to elaborate on this too extensively because it is well established in our law that the selection criteria need only be fair and objective. But where the LAC began in its reasoning was that it first began with an assumption without dealing with the issue or without finally deciding the issue. Its assumption was that individual performance appraisals, disciplinary records, and attendance records, those would constitute objective criteria. However, that is not as far as the matter goes, because even the introduction of objective criteria like that would not necessarily cure the potential subjectivity of a questionnaire. So in other words, even though there are objective elements in a criteria, those objective elements may not be enough to overcome the challenge that is posed by the subjective elements that are in that same criteria. And so the court went on to really consider the questionnaire. And it really started looking first at the objective. And as I had mentioned earlier, the objective was about retaining the skills in an environment where people would be required to act quite independently and at a high level. And I mean, I felt it would be useful just to take you through some of the questions, not all of them, but in effect, what the employer did was create certain important objectives. So they wanted someone with a strong analytical mind, someone who was good at multitasking, communication, initiative, etc., etc. Well, those are just some of them. And among the questions that they asked were, how important do you view having a strong analytical mind in the workplace? Or how important do you view multitasking in the workplace? Or what do you believe to constitute good communication skills? And so on and so on. So it was questionnaires that really asked the opinions or the views on certain skills and the abilities of the employees in question. And in its analysis, the Labour Court found as follows. So the first thing was that the questionnaire was focused on personality characteristics. You know, it tried to, or through the questions that the questionnaire posed, it really tried to glean people's views on certain things. The second one was that although past performance had been considered, there was no on-the-job evaluation that formed a component of the assessment. And then finally, and perhaps most significantly, the LAC found that the questions were entirely problematic in nature. They were double, they were open-ended, and they focused rather on the employee's ability to explain the importance of certain skills as opposed to actually testing the skill. So I mean, notionally, the person who could articulate themselves the best in the questionnaire would be able to, would have better chances of being retained post restructuring. And so ultimately, the court found that on that score, the selection criteria was not fair and not objective. And as a result, the appeal was upheld. There was a second part or a second factual matrix in this judgment, which I'll deal with very briefly. But it related to a singular employee who, at the time when the restructuring started in 2015, he had been dismissed a few months earlier. And what had happened was he had lodged his dispute at the Labour Court, and he secured an order saying that he must be reinstated. And this was shortly before the restructuring became a reality. So at the time of his dismissal, he was a washcoat operator. And when he was reinstated, he wasn't put back into that position. So he actually wasn't reinstated. Instead, his new position was as a storeman. And of course, as things so happen, when the retrenchments came around, the new department he was in was affected, and so he was dismissed. However, his previous position as a washcoat operator, which was of course the position into which he was supposed to be reinstated, was not affected. So in short, he would not have been affected by the retrenchment had he been reinstated. And so on that basis, his dismissal was also found to be substantively unfair. So I think on both scores, a very interesting judgment. I think it's very practical and shows the ways that the court is going to think, and I guess the way that employers should think when deciding on or thinking about or formulating a selection criteria. Thank you.
Ayanda, and it shows also just the level of interrogation that the Labour Court will apply to selection criteria and the evidence that you need to kind of cross that to meet that onus. Yeah. We again staying within the realm of retrenchments. Our next case, Amandla, who is very familiar to all of you, a senior associate in our practice area, who also is very familiar and does lots of litigation, is going to be next case, which is a bit more of a technical case again, dealing with the importance of issuing a Section 189(3) letter. Thanks, Amandla. I'm not sure if it's just on my side, but I think Amandla's screen may have frozen. Amandla, just checking if you're okay. If Amandla is, I think, might be experiencing some technical difficulties, so I think we will just move on to our next case while we get that sorted. Our next two cases both deal with agreements, and Nadine, a partner in our practice area, is going to be taking us through both of those. So, Nadine, if you can just move straight from the one into the next. The first one deals with voluntary retrenchment agreements and gives you just gives some, I suppose, a bit of a warning of how you need to approach those in your consultation process. And the second one deals with having settlement agreements made in order of court. Thanks, Nadine.
Thanks very much, Helen, and good morning, everyone. And the first case I will be addressing is WBHO Construction versus Messina & O and others. And as Helen has mentioned, this Labour Court judgment highlighted certain issues concerning the conclusion of mutually agreed terminations in the context of retrenchment proceedings. Now, in this matter, the employee who was employed by WBHO Construction as a final level grader was approached by a company representative, Mr. Gray, who initiated discussions with the employee concerning the company's operational requirements. Now, during these discussions, the employee was asked whether he would transfer to the Northern Cape, which was an area in which the company required his services. The employee refused the transfer, and subsequently the company and the employee entered into what was termed a mutual separation agreement. Now, the terms of the agreement reflected, amongst other things, that the employee, following consultations between the parties, was to be retrenched. The employee was to be paid a retrenchment package, and the employee acknowledged that his retrenchment was in full and final settlement of any claims. Now, notwithstanding this, the employee elected to refer an unfair dismissal dispute to the Bargaining Council of your civil engineering industry and argued that he had in fact been misled into signing the mutual separation agreement, or that he at least signed it under misrepresentation or duress. Now, the Bargaining Council arbitrator found that no retrenchment procedure had been followed by the company, as required in terms of Section 189 of the Labour Relations Act, and further that the employee had been pushed or at least dismissed, and that there was no reason to terminate his services. So in these circumstances, the arbitrator held that the dismissal was procedurally and substantively unfair and ordered the employee to be reinstated, or at least alternatively the maximum amount of compensation. The company was of course aggrieved by this decision and took the arbitrator's award on review. Now, before the Labour Court, the parties agreed that there were three main issues, or questions at least, that the court was required to determine. First was whether the arbitrator's finding that no procedure was followed by the company was reasonable. Second, whether, given the existence of this mutual separation agreement, the arbitrator's decision that the employee was unfairly retrenched was irregular. And thirdly, whether an employer may circumvent the retrenchment procedure in Section 189 of the LRA by signing a mutual separation agreement. So as regards the first issue in respect of no procedure being followed, it was common cause before the court that Mr. Gray had had discussions with the employee about the company's operational requirements, and that a mutual separation agreement had been concluded in which the employee received severance pay. Now, Section 189, as we all know, provides for a procedure that must be followed by employers when it contemplates dismissing employees for its operational requirements. Yet no evidence was placed before the arbitrator concerning any retrenchment procedure being followed, or any procedure followed for that matter. So the court found that the arbitrator's decision that the company did not follow any procedure was a reasonable one in the circumstances. In respect of the second issue, which was whether, specifically given the mutual separation agreement that had been concluded, the finding that the employee had been unfairly retrenched was irregular, the court noted that the mutual separation agreement was in effect a retrenchment document. It confirmed the employee's retrenchment, it detailed a retrenchment package, and on this basis, the arbitrator proceeded to determine whether the employee's retrenchment was fair. It found that it was not fair, and in fact, the employee was pushed to terminate or to at least be dismissed. And in these circumstances, the arbitrator's finding in this regard was not irregular. With reference to the third, and I suppose the primary issue in this matter, as to whether an employer may circumvent the retrenchment procedure in Section 189 and conclude a mutual separation agreement, the court placed much emphasis on the contents of the document. Although referred to as a mutual separation agreement, it was a retrenchment document. Again, as mentioned, it confirmed the employee's retrenchment, it referred to a retrenchment package, and it even referred to retrenchment in the full and final settlement of all claims. So the court found that the employer had in fact intended to retrench the employee, and instead of complying with Section 189, the employer chose to circumvent this procedure and decided to enter into a mutual separation agreement. Now, turning to consider the validity of the mutual separation agreement, the court noted that it is quite trite in law that each party needs to be deliberate in contracting with one another, and the parties need to have a meeting of the minds in respect of the terms of the agreement. Now, the parties' intentions in these matters was quite significant in respect of whether the mutual separation agreement was valid. The court found that the company obviously intended to retrench. This was clear from the face of the document. But based on the employee's argument that he had been misled or that he'd signed the agreement under misrepresentation, the employee was signing a mutual separation agreement. He did not intend to be retrenched, and on this basis, there was no meeting of the minds, and the court found that the mutual separation agreement should, in effect, be ignored. So in these circumstances, the court held that the company was not entitled to rely on the mutual separation agreement to circumvent your consultation process as provided for in the LRA, and that once it had contemplated the need to retrench the employee, it was obliged to commence the procedure in terms of Section 189. Thus, the arbitrator's finding in respect of the unfair retrenchment was a reasonable one. And lastly, turning to costs, the court stated that something needed to be said relating to the company's conduct. It transpired that the company was obviously an experienced construction company, and in fact, it had retrenched this employee in 2015, having followed proper retrenchment processes with its human resources department. Despite this, the company obviously chose a shortcut and circumvented the procedure. Further, the employee had represented himself at the hearing and had, in fact, at the time disclosed financial challenges to the company. And the court was of the view that the company had used this information to its advantage and to lure the employee into entering into a mutual separation agreement. And it really was for these reasons that a cost order against the company was warranted. Now, we have a few concerns relating to the judgment. Whilst it wasn't a lengthy judgment, it was fairly repetitive, and there were a number of aspects that weren't clear on the face of the judgment. For example, it was not clear whether the arbitrator actually considered the mutual separation agreement and whether it was valid, although this was a specific issue that the Labour Court was required to determine, and whether the decision was irregular given the existence of the mutual separation agreement. In respect of the intention of the parties, the court based it on the employee being misled or being under misrepresentation, but it's not clear whether any evidence was led by the employee in this regard, or whether in respect of the agreement, the actual employee was paid a gratuity or an amount in addition to what he would have been entitled to by law. And it's hard to believe that given the contents of the agreement, with the word retrenchment appearing on various pages, that the employee didn't intend to be, or have at least the intention to be retrenched when signing it. We all know that voluntary retrenchment agreements, which are concluded in the context of retrenchment proceedings, have found to be valid by our courts. And this is, of course, when an employee volunteers to be retrenched, there is an agreement in which the employee is paid a gratuity or an enhanced severance package, so an amount more than what he's entitled to. And this is normally phrased, obviously, as a voluntary retrenchment agreement. So one does wonder whether, if this agreement had the title voluntary retrenchment agreement, whether the court may have found differently in the circumstances. But nevertheless, just some key takeaways for employers following this case. It really does illustrate the importance for employers to be cautious when entering into sort of mutually agreed terminations in the context of retrenchments. Where you are faced with operational requirements and seek to terminate, we would advise that you first commence a Section 189 consultation process. You issue the Section 1893 letter and you commence consultations, and the option of a voluntary retrenchment agreement can be raised as an alternative to a forced retrenchment during the consultations. Of course, when entering into such an agreement, the agreement should reflect a voluntary retrenchment. It should indicate the employee volunteered for retrenchment, that he is receiving an enhanced severance package and a gratuity in exchange for this. And on this basis, he waives or he or she waives any claims against the company. If an agreement is concluded in these circumstances, we do believe that you'll have greater chances of it being found valid and not experiencing the same issues that transpired in this judgment. So that was the first case. And if I move straight on to my second case, which is a fairly short judgment, and that is of Mabaso versus Discovery Life. And this judgment concerned, as Helen mentioned, another agreement, in fact, a settlement agreement concluded by an employee, and whether it could be made an order of court. So briefly in this matter, the employee was employed as a team lead by Discovery Life, and unfortunately, Discovery Life initiated a retrenchment process in terms of Section 189, with the employee being one of the potentially affected employees. Now, all the affected employees were offered a voluntary severance package, which provided for a gratuity and an enhanced payment to be made. The employee was given the voluntary severance agreement, but the employee did not sign the agreement at the time. A month later, the employee signed the agreement, and the employee signed the agreement conveniently on the same day in which he admitted that he had conducted this elaborate fraud against Discovery Life and had stolen around £500,000, which is approximately 11 million rand from Discovery Life. In terms, of course, of the voluntary severance agreement, the company, Discovery Life, was required to make payment to the employee, and when the company didn't, the employee approached the Labour Court to make the agreement an order of court. Not surprisingly, Discovery Life opposed this application, arguing that it was deceitful and at least ill-conceived, because firstly, the settlement agreement was not an agreement as contemplated in terms of the Labour Relations Act, and the validity and enforceability of the agreement was in dispute. Discovery Life's defense was, of course, that there was a material misrepresentation when the agreement was concluded, and had Discovery Life known about these material facts that were not disclosed, it would not have entered into the agreement, and it elected to resolve from the agreement on the basis that it was invalid and unenforceable. So in considering the matter, the Labour Court first considered your relevant legal principles. Now, Section 1581C of the Labour Relations Act empowers a court to make any arbitration award or settlement agreement an order of court. But this section must be read with Section 1581A, which defines the term of a settlement agreement. And a settlement agreement for purposes of this section is defined as a written agreement in settlement of a dispute which can be referred to arbitration or to the Labour Court. Now, the Labour Appeal Court has reiterated that Section 1581C about making agreements in order of court must be read with and is subject to Section 1581A. So one has to meet the definition of a settlement agreement before it can be made an order of court. So there's a few requirements here in terms of a settlement agreement. Firstly, it must be in writing. Secondly, it must be in settlement of a dispute. Thirdly, the dispute must be one that the party has a right to refer to arbitration or to the Labour Court for adjudication under the Labour Relations Act. And the dispute must not be one where it can only be referred to arbitration, and there's certain limited disputes in this regard that are accepted from this. This is disputes concerning organisational rights or disputes in respect of essential services or maintenance services. It is to be noted that the Labour Relations Act doesn't oblige the court to make a settlement agreement an order of court. The court still has a discretion in this regard. So in summary, against the background of these provisions, when deciding to make a settlement agreement an order of court, the court would first have to determine whether the settlement agreement meets the requirements and criteria as defined in Section 1581A. If it does not, the court has no discretion and it cannot make the settlement agreement an order of court. If it does, the court then needs to consider the facts and circumstances and use its discretion to determine whether to make the settlement agreement an order of court. So applying these legal principles to the facts of this matter, the obvious question was whether the agreement entered into by the employee met the criteria under the LRA. Now, yes, it was in writing, and it sought to terminate the employee's employment by way of a voluntary retrenchment. But the court then canvassed the issue regarding of whether there was a dispute, and it asked the employee during his submissions what the dispute was between the parties, to which the employee responded that the dispute was Discovery Life had not paid him the payments made under the agreement. The court, however, found that this was not a dispute. That was a dispute envisaged under the LRA that could be referred to arbitration or the Labour Court. And in fact, at the time of signing the agreement, there was no dispute between the parties. This is a dispute that had subsequently rose. So in the context of, excuse me, of a voluntary retrenchment agreement, it does not constitute a dismissal. There's no dispute between the parties. And on this basis, it doesn't meet the criteria. Of course, if the employee, similar to my previous case, maybe allege that he was misled into entering the agreement, or he did so under duress. You may have a dispute and it would be different circumstances, but in this matter, that was not the employee's case. So the court decided that it was not satisfied that the settlement agreement met the definition of a settlement agreement under section 158(1)(a), and the court did not have the discretion to make the agreement an order of court, and the application was dismissed. So just to note that employers, or if you're dealing with a matter of a similar nature, to have regard to the definition of a settlement agreement in section 158(1)(a), it is important in respect of making an agreement an order of court, and that a voluntary retrenchment agreement or an agreement to mutually terminate where there's no dismissal would arguably be not a settlement agreement that can be made an order of court. But there are, of course, other remedies available to the employee. The employee could have arguably gone on breach of contract to seek an order for specific performance or to enforce the agreement, but that wasn't the case before the court, and it could not be made an order of court as contemplated under the Labour Relations Act. Thanks very much, Helen.
Thanks, Nadine. So one fairly controversial judgment there, but I think some good about, I think we all kind of think once an agreement's signed, it's the end of it. But I think some good practical points out of those two cases. We're going to move back to Ayanda, staying in the realm now of employee misconduct, who is going to take us through an interesting case dealing with comments made by a colleague and the impact of this on the working relationship. Thanks, Ayanda.
Thank you. It's me again. And I'm very glad you didn't spoil what the comments were, Helen. So the matter I'm now dealing with is a Labour Court judgment in the matter between Tempest Car Hire and CCMA and two others. This came to the Labour Court as a review application. And really, the importance of this judgment is that it deals with concepts of, well, material disputes of fact, how to resolve them, and also considerations of credibility and reliability of witnesses and versions, respectively. So anyway, onto the facts. The facts take us back to March 2021. When one day an employee who goes by the name Miss Mudley, she was a customer service agent at the company. And on this particular day, she arrived to work feeling quite under the weather. So as one does, she told her colleagues, and she sort of went to the kitchen area to try to relax and take a load off, telling her colleagues to call her when things get busy. At some point while she was in the kitchen area, she was with another employee who becomes the subject of these proceedings, who goes by the name of Buseletso Lebiane. I'll just refer to her as the employee. The employee hears Miss Mudley say that, you know, she's feeling sick, she's feeling under the weather. And in response, the employee simply says to her, "You should die." And after a moment of, I guess, or what I expect to be very awkward silence, the employee says, "No, I was just joking, meant nothing by it." But of course, Miss Mudley, she took it to heart and she immediately went to go lodge a grievance. So the employer underwent a grievance procedure, which was overseen by one of its employees by the name of Miss Fender. And the finding in the grievance procedure was recorded a few important things, or things that will become important in the later Labour Court judgment. And the first of those things was that there was a very bad historical relationship between the two, and that had a material impact on the dynamics in the workplace. Also, what was significant was that the employee during the grievance procedure admitted to making those particular utterances. And then the third thing was that Ms. Venter recorded that the utterances, although they were not life-threatening, they were extremely serious. And on that basis, the employee was subjected to a disciplinary inquiry, subsequent to which he was dismissed. And of course, he then went to the CCMA, having referred an unfair dismissal dispute. Now, at the CCMA, a new version emerged from the employee. What he said was that, no, I didn't say to Ms. Moodley that she should die. Instead, what I was doing was showing concern, because what I said to her was, you could die. And of course, that presented a mutually destructive version to what the employer presented, being that the employee had said to Ms. Moodley that she should die. So ultimately, the commissioner at the CCMA had to consider these versions. And what the commissioner found was that the witnesses who appeared on behalf of the employer, they were unreliable, and their versions, or rather they were not credible witnesses, and the versions that they provided were unreliable. And on that basis, the employee's dismissal was substantively unfair. So of course, the company took this award on review to the Labour Court. And the Labour Court on review, what the company argued was that the commissioner had ignored certain material evidence, which of course impacted the outcome of the award. Now, I found this judgment to be quite interesting for another reason, other than what I had mentioned in the introduction. And that's because of the comments made by the court about the general trend that we find in some CCMA awards. What the court described it as, with reference to other judgments, in fact, the court described it as a lack of logic in some of the awards. So there will be very detailed summaries of the evidence and things like that. But once you get to the analysis section and conclusion section of the award, the reasoning really starts to become thin. And in this particular case, where we had mutually destructive versions and factual disputes, what the Labour Court found was that the commissioner there did not adequately deal with these factual disputes. So, for instance, in respect of the credibility finding, the commissioner had found that Ms. Venter was not a credible witness because at the grievance, she had recorded that this was not a serious this was not a life-threatening issue, but of course that it was serious. However, at the arbitration, she had said that this was indeed a life-threatening scenario or situation. And what the CCMA had found was that on that basis, because of that contradiction, she was completely a not credible witness. And what the Labour Court said in reviewing that decision by the CCMA, well, it found that this was really the only contradiction in an otherwise consistent story. And if a witness on the stand only really has one or two minor contradictions, one cannot make a finding that that witness is not credible. And then there was also the issue of reliability. And what the commissioner had found there was that because the witnesses who appeared on behalf of the employer were not in the room when the utterance was made, they were not reliable witnesses. However, there was other evidence that the Labour Court had emphasized and found that the CCMA ignored. Chief among these was the fact that both Ms. Venter and another employee, they said that the employee had come to them at different times and admitted to making the utterances. And this was ignored by the commissioner. What was also ignored was the historic relationship between the two, as well as the process that followed. In fact, following the grievance process, Ms. Moodley had resigned because she had felt that the workplace was not good anymore, that the relationship with this particular applicant was not sustainable or feasible anymore. And on that basis, the Labour Court found that the award that was issued by the CCMA was indeed capable of being reviewed and set aside. And what the Labour Court did was they remitted the matter back to the CCMA. Although, I guess the reason for that was because we're dealing with a material dispute of fact. They wanted to take it back to the CCMA to have the initial trier of facts who would look at the things like demeanor, the credibility of the witnesses all over again. Although an argument could be made that all the evidence was there before the court and it could quite easily have made a finding without remitting the matter. So yeah, very interesting judgment. It speaks a lot about witnesses. I think companies, one of my main takeaways is that, we often deal with circumstances where the complainant or someone complaining on behalf of someone else wasn't in that particular room. And, it presents a hurdle for us very often, but that is not completely destructive of that evidence. And, what one really needs to look at is the probability of the story and the surrounding circumstances and things like that. So yeah, thank you, Helen. And that's the case.
Thanks, Ayanda. Yeah, sounds like quite a long saga for the employer concerned. We know that well less than half of reviews are successful. So I think that lack of logic piece is probably quite a compelling point in that one. We're going to move back now to Amandla. He's going to take us through her two cases. The first relates to the necessity to whether or not a Section 1893 notice is a legal necessity. And then, Amanda, if we can move straight into your second case, which I think, again, is a very interesting one, dealing with the level that what evidence is acceptable to show a breach of the trust relationship in a misconduct scenario. Thanks, Amanda.
Thanks, Helen, and good morning, everyone. So in this case, the Padayachi versus Serrero case, and I believe that the citation will be on the chat. The Labour Court was called upon to review and set aside the arbitration award, where the arbitrator found that a dismissal of a retrenched employee was substantively and procedurally fair. Now, the facts of this matter are interesting. The matter occurred in 2019. The employer is the Joburg Property Company. It decided to restructure its corporate structure, which would have an impact on various job positions, including the Information Technology Department and a position occupied by the employee being the head of IT. What's more interesting in this case is the employee was part of the ExCo, where this structure was tabled, discussed, and deliberated on. And this structure also was presented to the local labor forum. It was discussed with the various trade unions. Amongst them was IMATU, which was the trade union representing the employee. Now, the employer did not issue a Section 189 subsection 3 notice, which is vital when you are commencing retrenchment processes. It didn't issue it to the employee or to the union, being IMATU. Then what happened is on the 30th of September 2019, the employee was dismissed based on the employer's operational requirements. Naturally, she referred an unfair dismissal dispute to the South African Local Government Bargaining Council, which found her dismissal to be procedurally and substantively fair. Disgruntled by this outcome, she then instituted review proceedings in the Labour Court, alleging that her dismissal was unfair as the employer did not issue her with the Section 189 notice. So it was non-compliant with the Labor Relations Act. In considering the substantive fairness of the employee's dismissal, the Labour Court had regard to Section 188, subsection 1A, Roman figure 2 of the LRA, which provides that a dismissal is substantively unfair if the employer, among other things, fails to prove that the reason for dismissal is fair based on the employer's operational requirements. So the Labour Court in this regard reiterated that the test to evaluate the substantive fairness of a dismissal related to operational requirements is that there is a fair reason, one that is bona fide and rationally justified and informed by a proper and valid commercial or business rationale. The court also reiterated that the inquiry into the rationale for operational requirements is not to ascertain whether it will be chosen by the court, but whether it is objectively fair. The Labour Court found that the Commissioner's findings in this regard was reasonably justified, as it was in line with Section 188(1)(a) and Section 213 of the LRA, as well as the Code of Good Practice dismissals based on operational requirements. In that the employer had a valid and fair reason to terminate the employee's employment based on the operational requirements, which the employee was well aware of, having been part of the EXCO and having been consulted through her union being IMATU. And what's also important in this case is that the employee was offered alternative employment, but she rejected it on the basis that there was a salary cut. And on whether her dismissal was procedurally fair, the Labour Court acknowledged the decision of the Constitutional Court in solidarity on behalf of members versus Barloworld Equipment South Africa, which was issued in 2022, and Bowmans had the pleasure of representing Barloworld in that case. This case is authority for that Section 189, subsection 3, makes it obligatory for an employee to issue a written notice to consulting parties, inviting them to consult and disclose in writing all relevant information specified in Section 189 3A to J of the LRA. However, considering the peculiarity of these facts, the court considered that the employee was sufficiently aware of the restructure and that her department would be impacted and that her position specifically would also be affected. There's been extensive consultations and discussions on the structure with the various trade unions, including IMATU. And she was well aware of what was going on. And there had been correspondence exchanged with the trade unions, including IMATU, to the effect that it would not be necessary to issue this Section 189 3 notice because of the parties being aware of the basis of the restructure and the proposed retrenchments. And that was never rejected by IMATU. So the Labour Court held that the employer had substantially complied with Section 189(1), 2, and 3A of the LRA. And as such, there was meaningful and joint consensus-seeking process that was not necessarily contingent on the issuing of this notice. Moreover, even IMATU itself, being the trade union representing the employee, agreed that there was substantial compliance with Section 189. So the Labour Court in this regard held that the Commissioner's findings were unassailable and they fell within the bounds of reasonableness. And accordingly, the Labour Court confirmed that the employee's dismissal was substantively and procedurally fair. I would say this is one of the judgments that I've read where the Labour Court says this particular commissioner fairly dealt with the facts and really applied his mind to it. Now, the key takeaways from this case is that the Labour Court has cautioned that this decision should not be taken as precedent for employers to not issue the Section 189.3 notice. It's still a mandatory notice, and it's still vital when you're commencing these retrenchment processes. And we would continue to advise that employers comply with the letter of the law and ensure that this notice is issued to the relevant parties, not only because of compliance, but because this notice serves as an invitation to meaningfully consult, as well as evidence that you have called the parties to engage on what aspects are they being consulted on or engaged on. And it is also a marker that commences the time period for consultation, especially in large-scale retrenchments, where you have to be mindful of the time periods set out in the LRA. Now, Helen, I'll move swiftly to the next case, being the Algoa Bus Company versus TASU on behalf of Mzawi. This is another interesting one, considering what we see happening on our roads almost on a daily basis. So in this case, the employee was employed by Algoa as a bus driver. She's been with Algoa for approximately 6 years and in that position as a bus driver. Now, Algoa has a disciplinary code and procedure that sets out various forms of misconduct, one of which being if you skip a red light, then you might be issued with a final written warning. But if you skip a red light with some consequences, let's say an accident of some sort, then you would be the appropriate sanction would be dismissal. Now, what happened here was that the employee was approaching an intersection. The traffic light turned amber. Instead of applying her brakes, she accelerated. And when she got to the intersection, she skipped the red traffic light. Unfortunately for her, her bus collided with the minibus taxi, thus causing an accident. This whole event was captured on video footage through a camera mounted on her bus. So obviously the company runs through the process and she's dismissed. Aggrieved by her dismissal, she approaches the South African Road Passenger Bargaining Council. And during the arbitration, she denies that she's the cause of the accident. And she argues that it is the minibus taxi that caused the accident, even though there's clear evidence that she skipped the red traffic light. Now, she also argued that the sanction of dismissal was disproportionate to her misconduct, especially because no one sustained injuries. So basically, no harm, no foul, touche, your bus is toast at this point. Because she's saying, since no one got injured, I can't be dismissed. So for her, the consequence that is referred to in the disciplinary code was somebody else being injured. She didn't pay attention to the fact that the bus was damaged. The minibus that was involved in the collision was damaged. So the commissioner found that she was a professional driver. For over 6 years, she had contravened the road traffic rules and had shown no remorse for her conduct. The commissioner found that the sanction of dismissal for her misconduct was appropriate and was in line with the company's code, and that the employee's conduct had undermined the trust relationship on which the employment relationship was built. So the commissioner upheld the dismissal. Naturally, she approached the Labour Court to review the commissioner's decision, and she was still represented by TASU at that point. So the Labour Court accepted the commissioner's factual findings in respect of misconduct committed and on the evidence. However, the Labour Court disagreed with the commissioner's award on the appropriateness of the sanction of dismissal. In this regard, the Labour Court found that the company was obliged to adduce evidence to sustain the contention that dismissal was appropriate. Now, the court held that the evidence required, for an example, is that the trust relationship between the employer and the employee had broken down. So the company had not specifically adduced that evidence when they were discussing the appropriateness of the sanction. And the court said, in the absence of this evidence, the fairness of the dismissal could not be confirmed because it would then be based on speculation. Moreover, the Labour Court was not convinced that the employee's misconduct was serious as to warrant an inference of a breakdown in the trust relationship, as would be the case where there's gross dishonesty. On this basis, the Labour Court found that the commissioner had misconducted himself in arriving at a conclusion that dismissal was fair, and he then, set aside the arbitration award and ordered that the employee be reinstated. Now, obviously, this didn't sit well with ALGOA, and ALGOA approached the Labour Appeal Court to appeal the Labour Court's decision. On appeal, the Labour Appeal Court highlighted the Constitutional Court's judgment that we all are aware and familiar with now, being Sidumo and Another versus Rustenburg Platinum Mines, which specifically enjoined arbitrators to consider all the relevant circumstances and make a value judgment as to the fairness of the employer's decision. Now, the Labour Appeal Court also indicated that this injunction in Sidumo is repeated in the CCMA guidelines on misconduct arbitration. So there are those guidelines for commissioners, and lately we've been referring to them when we're dealing with commissioner misconduct. So in this respect, the LAC held that the absence of any specific evidence regarding a breakdown or deterioration in the employment relationship is not a basis to set an arbitration award upholding a dismissal. The LAC added that while a deterioration in the trust relationship may be relevant or even a significant factor in determining the fairness of a dismissal, more often than not, the evidence of the nature and extent of the employee's misconduct will be sufficient for an arbitrator to exercise the required value judgment on the fairness of a dismissal. Accordingly, the LAC reiterated that the existence of serious misconduct can lead to a finding that a dismissal should be upheld without evidence of any breakdown in trust. The LAC found that the commissioner had holistically considered all the facts before him, including that the employee saw the amber traffic light on the road as there was no obstructions, had accelerated than applying brakes to bring the bus to a stop, and actually drove through a red traffic light, which led to serious consequences in that there was a collision. The commissioner also had considered the employee's denial of any misconduct and her lack of remorse, which suggested that corrective discipline was unlikely to cure her behavior. In this regard, the LAC found that the commissioner's assessment of the evidence regarding the appropriateness of dismissal as a sanction could not be faulted, and there could be no question that the decision was one which a reasonable decision maker could have reached. Accordingly, the LAC upheld the appeal and set aside the decision of the Labour Courts. The lady remains dismissed. What is significant about this case is that the LAC has confirmed that there is no general obligation on an employer to lead specific and discrete evidence as to the appropriateness of dismissal as a sanction for misconduct to show that a dismissal is fair. We would still advise that just deal with it holistically, deal with the trust relationship, the breakdown thereof, and when you are conducting the disciplinary processes and when you are defending against these allegations of unfair dismissal, just to holistically cover all your bases. Also, we understand the LAC to have placed an emphasis on the importance for an employer to present sufficient evidence, as I've said, including in the nature of and the seriousness of the misconduct and its consequences, so that the fairness of the dismissal can be assessed from the totality of the evidence before the arbitrator, and to empower the arbitrator to make the necessary value judgment as to the fairness of the decision to dismiss an employee. Helen, thank you very much. That's the end of the cases.
Thanks, Amanda. That is a uniquely South case, and obviously reiterating a principle that will be welcome to employers. It would be quite difficult to explain to people overseas that a professional driver robot is not a dismissible offence, as the Labour Court found. Moving on to Sabu in our next case. Sabu is obviously very familiar in our Sandton office, dealing with an automatically unfair dismissal claim. And I think the facts of this, Sabu, are very interesting. The grounds, the alternative grounds that were submitted by the employee, very, very different alternative grounds. Thanks, Sabu.
Thanks, Helen. And yeah, good morning to everyone. I hope everyone is well this morning. So the case that I'm dealing with is Slubbert and Muji Motor Group. And essentially in this court, the Labour Court, in this case, the Labour Court had to determine whether or not Mr. Slubbert's dismissal was an automatically unfair dismissal, which arose or came about as a result of a transfer in terms of Section 197, or a reason related to a transfer in terms of Section 197 on the one hand, and on the other hand, or in the alternative, whether or not Mr. Slubbert's dismissal based on his age constituted an automatically unfair dismissal. Now, the material facts of this case is that Mr. Slubbert was employed by a company called Autohouse in terms of an oral agreement back in 2003. Now, the oral agreement did not provide for a retirement age, and over the years, this was just not discussed. So there was no agreed retirement age regulating Mr. Slubbert's employment. In 2013, at the tender age of 65, Mr. Slubbert was promoted to the position of sales consultant, and his role was thereafter refined in 2018 to that of a sales manager. And at this point in time, he was 70 years old. In 2020, the respondent then took over Autohouse as a going concern. And at this time, Mr. Slubbert is 72 years old. So the owner of the respondent had a meeting with Mr. Slubbert where he essentially informed him that he has reached his retirement age. And this is because in the motor industry, the normal retirement age is 65. This was followed by a notice to Mr. Slubbert informing him that he is essentially being placed on retirement. Mr. Slubbert then referred the automatic unfair dismissal dispute to the Labour Court, and the Labour Court then had to grapple with the question as to whether or not this dismissal arose because of the transfer, or whether 65 was the normal retirement age in the motor industry. Regarding the first question, the Labour Court determined that the proximate cause of the dismissal was in fact Mr. Slubbert's age. So the question that the court then had to determine was whether or not the dismissal of Mr. Slubbert could be justified on the grounds of normal retirement age. In looking at the case for the respondent's case, because there was no agreed retirement age, the respondent's case was that in the motor industry, there's a main agreement that governs the Motor Industry Bargaining Council. And in terms of that main agreement, it provides that parties to the council are members of two provident funds. And in terms of the agreements relating to those two provident funds, the normal retirement age is 65. So that was the crux of the respondent's case, is that the applicant was a member of MIPCO and therefore was bound by these two collective agreements, which then provided for a retirement age of 65. The Labour Court found that the applicant was not a member of the Provident Fund, and therefore the retirement ages that are set out in those collective agreements for both the provident funds were not a term and condition of his employment. What the respondent was required to do was to prove that 65 is actually the normal retirement age for people who are employed in the same position as the applicant in the motor industry. And the respondent had failed to do so. They had led no evidence which substantiates the age of 65 as being the normal retirement age. Accordingly, the court found that Mr. Slabbert's dismissal was automatically unfair and awarded compensation to him to the tune of 12 months. There were some very interesting legal findings that the court made in coming to this conclusion, or certain considerations which the court went through. And I'll just take us through some of them quickly. And the first one was that with regard to section 1872B, the court stated that if an employment contract does not terminate at the retirement age, and the employee continues to work indefinitely, that contract is considered as continuing. However, the employer does not waive their right to rely on section 1872B at any point in time. So in other words, even if a person has reached retirement age and they continue to work, you can rely on section 1872B to dismiss that individual at any point in time. Similarly, the court also found that, continuing to work post this period does not mean that there is a new retirement age. The only time a new retirement age will come into place is if the parties actually reach an agreement on the new retirement age, and this is noted. And finally, with determining or establishing what constitutes a normal retirement age, the court found that a normal retirement, or rather the word normal, includes the industry practice with respect to persons working in positions similar to that of the individual in question. In other words, you have to look at what is the practice in the industry for people who are employed in the same or a similar role. So there has to be a comparator and various other factors in terms of how long have people, been retiring at this particular age in this industry, and how many people in the industry have retired at this age for it to be considered a normal retirement age. I think that's pretty much what the case dealt with. Thanks, Helen.
Thanks, Vu. Good to have again confirmation just on those retirement principles. Soraya, an associate in our Sandton office, is going to take us through our next case. And I think for any businesses who have contracts with clients and the employees assigned to those contracts and client sites are going to find this case fairly interesting in the context the client tells you that they no longer want your employee on site. Soraya, over to you.
Thank you so much, Helen, and good morning, everyone. I'll be discussing the Labour Court case of Silver Security Solutions versus Sayman. So just a brief overview. The Labour Court in this case concluded that the defence of supervening impossibility could not be invoked without evidence of the alleged prior misconduct. It further emphasized fairness in dismissal processes, asserting that an employer should consider alternatives to terminations. So ultimately, the Labour Court held the CCMA's decision that the dismissal of a Ms. Kulati was unfair and ordered that Silver Solutions pay the legal costs of the employer. So some brief backgrounds of the facts of the case concern Ms. Kulati, who was an employee of Silver Solutions and who was a work at the Kuche port in Kebega for Transnet. Silver Solutions provided personnel to Transnet under a service level agreement. Ms. Kulati's tenure at Silver Solutions proceeded without any incident until a situation arose that Transnet deemed unacceptable, resulting in the denial of her access to the workplace. Consequently, Silver Solutions removed Ms. Kulati from her position. And following this, reportedly unable to find a suitable alternative position for her, Silver Solutions notified Ms. Kulati to attend a poor capacity hearing. It was alleged prior to this hearing, Silver Solutions inquired with Transnet whether there were possible alternatives to her. However, Transnet remained resolute. The incapacity hearing ultimately led to the termination of her employment. Ground Transnet's refusal to grant her access, following accusations of her soliciting money and chocolates from a crew member on a vessel. He subsequently referred the matter to the CCMA as an unfair dismissal dispute. So the findings at the CCMA: the arbitrator determined Silver Solutions had unfairly terminated Ms. Kulati's employment. This conclusion was based on the basis that Silver Solutions did not provide adequate evidence to demonstrate reasonable efforts to persuade Transnet against proceeding with the demands for her removal. The arbitrator noted that in such circumstances, Silver Solutions ought to have followed a more rigorous and thorough approach when finding alternative solutions. Following the CCMA award that Ms. Kulati's dismissal was procedurally unfair, Silver Solutions sought a review, arguing that the award was effective and challenged it on several grounds, namely that the arbitrator failed to consider material evidence, there was a misunderstanding of the case evidence, and it was a departure from the terms of reference. The essence of Silver Solutions' argument was that the pertinent issues were whether indeed revoked by Transnet, whether Transnet possessed the right to revoke her access under the server level agreement, and the implications of these findings on Ms. Kulati's ability to fulfill her role. So some of the illegal analysis that was presented by the Labour Court, they said that for Silver Solutions to have succeeded in its review, it was essential for them to demonstrate that the arbitrator's decision was unreasonable. The Labour Court then referred the appeal court case of Bestel versus Astral, which outlined that a decision could be deemed unreasonable if it was unsupported by evidence, based on speculation, if it was disconnected from the evidence, supported by insufficiently reasonable evidence, or made without any consideration. Further, the Labour Court noted that it is crucial to acknowledge that the Labour Relations Act demands that dismissals must be fair in all respects. The nature of a dismissal dictates the factors that an arbitrator must consider to determine the fairness of a dismissal. In cases of incapacity, arbitrators are tasked with assessing whether an employee is unable to meet inherent requirements of a job, typically health issues, injury, or poor performance. However, our current legal framework allows for termination based on incapacity arising from a supervening inability or impossibility to perform job duties, provided that such termination is, of course. This implies that incapacity should not always be limited just to ill health, injury, or poor work performance, because this adaptation is for situations where an employee's permit, accreditation, license, or the like is cancelled, or where a host employer gives the employee access to its workplace, which of course doesn't concern the employee's capacity to perform the job. Moreover, the court emphasized the fairness in the rationale and pre-dismissal process, even in situation where dismissal arises from an impossibility to perform. So the findings of the Labour Court: during argument, Silver Solutions contended that it presented evidence supporting Transnet's right to access as outlined in its service level agreement. However, and during arbitration, Silver Solutions was unable to produce a copy of the level agreement, and this was alluded to by the Commissioner in his award. The court concluded that while Silver Solutions cited Ms. Kulati's incapacity, the decision to terminate her was fundamentally linked to Transnet's revocation of her access on alleged misconduct. Therefore, it was Silver Solutions' responsibility to establish Transnet's right to deny and to demonstrate that such actions were consistent with the service level agreement. The court found that the defense of supervening impossibility could only be invoked if there was a preceding reason directly leading to the initial impossibility. In this instance, the alleged misconduct served as the triggering factor for the subsequent claim of supervening impossibility. Of the alleged misconduct during arbitration was essential to verify that the impossibility was properly established. Transnet had legitimate grounds to revoke Ms. Kolati access to the workplace. Had Silver Solutions presented evidence of Ms. Kolati's or mitigating circumstances, it is plausible that Transnet might have reconsidered its demand for her removal. The absence of evidence by Silver Solutions casts doubt on the fairness of her dismissal. The assertion that Transnet's revocation, as stated in the service level agreement, automatically justifies dismissal is not supported by our legal framework. Commercial agreements should not be used to undermine employee rights or to enable unfair treatment. The court in this case also referred to another Labour Appeal Court decision, which was Leboa Platinum Mines versus Heels, which made it clear that the fact that a third party demands a dismissal of an employee would not render such a dismissal fair. As such, the court held that it was incorrect for Silver Solutions to suggest that the arbitrator's inquiry should focus solely on whether Transnet had the right to revoke Ms. Kolati's access and whether such revocation was permissible under the service level agreement. This perspective implies that an employer could dismiss an employee solely at the request of a third party. Silver Solutions could have demonstrated due diligence by exploring alternative solutions, such as relocating Ms. Kolati to another position within the organizations, which would have preserved her employment. Such actions would have illustrated fairness on the part of Silver Solutions. Overall, the arbitrator's decision was found to be fair and one that a reasonable decision maker would have reached. So in determining costs and in awarding Silver Solutions pay the legal costs of Ms. Kolati, the court emphasized that in employment law matters, equity and fairness are paramount. The decision made by Silver Solutions significantly impacted Ms. Kolati's livelihood, and her pursuit of the legal recourse was aimed at protecting her rights. So the order that Silver Solutions cover Ms. Kolati's legal costs reflects the recognition of her right to defend herself. So what are some of the key takeaways of the case? So this case highlights where an employers rely on incapacity to terminate the employment of one of its employees, even where the incapacity is based on supervening impossibility. Employers must substantiate claims of incapacity with adequate evidence and demonstrate reasonable efforts to explore alternatives to termination. Silver Solutions' failure to do so not only led to the unfair dismissal of Ms. Kolati, but also reaffirmed the principle that employee rights must be upheld regardless of external pressures from third parties. Thank you so much, Helen.
Thanks, Saran. I think that just underlines how commercial realities of the Labour Court is not going to be that concerned with commercial realities of the client relationship. If the client just says remove them and expects more of companies' employers, which we appreciate can sometimes make for fairly tricky scenarios, but some good key takeaways there. Thanks, Saran. Melissa, partner in our Cape Town office, is going to close out the update with us with two very different cases. The one deals with restraints of trade, which I think, Melissa, will probably be a welcome case for parties who regularly enforce restraints of trade. And then the second one, again, is a bit more technical case, which looks at the question of when you need to furnish security in a review application. Thanks, Melissa.
Thanks, Helen, and good morning, everyone. So the first case that I'm dealing with is the restraint of trade case. It's Commercial Mobile Truck and Trailer Alignment Services versus HARMSA. It's a decision from earlier this year in July of the Labour Court, and it dealt with a 5-year restraint of trade that operated within a 250-kilometre radius from the employer's business premises. And in addition to that, it also sought to enforce that in other African countries in which the employer operated or its associated company had an office. In this particular case, the proprietary interest that the company was seeking to protect was one of customer connection. So you know that you can protect your interests by way of a restraint of trade if it's either customer connections or if it's via confidential information, which is trade secrets. In this particular case, the business was that of a wheel alignment, balancing, and trailer repairs business, where the company would then service clients' vehicle fleets. So they would be servicing a number of repeat clients over a period of time. It was a service that was offered on-site or at the client's premises, and it was provided on a 24-hour basis. The case related to 2 specific individuals who had signed restraint of trade agreements. One was an operations manager, and the other was an assistant wheel alignment technician. They then resigned from employment, and they did so with immediate effect. And it later became known that one of those employees had, whilst he was still employed by the business, set up a competing business doing exactly the same work and was then soliciting the very same customers that he had serviced while he was at his previous employer. And the company showed evidence that, this solicitation of their business and their clients and use of those customer connections had materially impacted the revenue of the business drastically as soon as the employee had left the business. So the company then sought to enforce the restraint of trade. It actually was only enforced against one of the employees because there was only evidence that one of the 2 employees was involved in that specific competing business. The other employee had been engaged by another company that was not a competitor of the business. And in this particular case, the court restated some very well-known principles that are applicable in restraints of trade. It's one that they are enforceable. If you are seeking to enforce them, you just have to invoke it and prove that there's been an actual breach of the restraint of trade. So in relation to the one employee, they had proven a breach because he was competing with the business and he was soliciting customers. They couldn't prove the breach in relation to the other employee. Then once you've proven a breach, the onus is on the employee to prove on a balance of probabilities that the restraint is unenforceable because it's unreasonable. And it set out various factors that are relevant determinations in these restraints of trade cases. And it comes from a well-known case called Basson versus Chilwell. It looks at various factors, which is what is the interest that is being sought to protect? In this case, it was customer connections. Is it deserving of protection? Is that interest being prejudiced by the other party joining a competitor or competing with the business? The court then weighs up qualitatively and quantitatively the interests of the business versus the interests of the employee and their right to be economically active and productive. And then it also looks at factors of public policy. When looking specifically at the protectable interest of customer connections, the court reiterated the principles that are applicable there. It will look at the frequency and duration of the contact that the individual has with customers. Where does that contact take place? What knowledge does he have of the particular business and the customer's requirements? What's the nature of that relationship? And whether there's actually evidence that a number of employees did actually leave when the individual had left. So it has to show that there was a customer relationship that was built up and established whilst the person was still employed in the business, which was sufficient for the individual to gain influence over them so that they might actually move their business elsewhere when they leave. For employees, they would have to then show that they never acquired any significant personal knowledge of or influence over persons that they had previously dealt with. In this particular case, there wasn't much of a challenge by the employee that there were these customer connections. He didn't actually even really challenge the duration of the restraint, which is, as I said at the start of this presentation, it was a 5-year restraint. But the court said that even though the employee hadn't challenged the duration of the restraint, it did consider 5 years as an unreasonably long period of time, even if there's no evidence that was submitted by the employee saying that it was unreasonable. So the court looked at previous decisions in relation to restraints of trade for customer connections and had found that it is generally acceptable that you could enforce a restraint of up to 2 years for customer connections, provided that there's no evidence to suggest that a shorter period ought to be enforced. In other cases, 2 years has been found to be unreasonably long, but it all depends on the specific facts of a case. So the court also referred to another judgment where a 2-year restraint was reduced to 8 months in a customer connections. In this particular case, the court declined to uphold the 5-year period of the restraint, upheld it for 2 years, and also the employer had conceded that they wouldn't be enforcing the restraint in the other African jurisdictions or related entities. It didn't give reasons as to why, but presumably I would assume that the reason why they couldn't enforce in those jurisdictions was because the employee was not actually operating in those other jurisdictions or creating connections with customers in those jurisdictions, or perhaps he just wasn't privy to confidential information pertaining to those other jurisdictions. So just a key takeaway from this particular case is that, restraints are enforceable. Consider the protectable interest that you're seeking to protect that is actually being prejudiced by somebody, and look at, the geography of the application of the restraint, make sure it's not unreasonably wide, and make sure that the duration is no longer than is necessary to protect your interest. In the second case the last case for the session that we're going to be dealing with today is called Africa Bin Building Systems versus Magaladi and others. It's a 2024 decision from this year, also from the Labour Court, and it pertains to the furnishing of security in review applications. Here, the employer had reviewed an arbitration award of the CCMA. So you might know that in a review application, if there is an arbitration award from the CCMA or a bargaining council that has awarded reinstatement or compensation, it must be known that if you want to review it, it's not going to automatically suspend the operation of that arbitration award. The employer who is reviewing the arbitration award has to furnish security to the satisfaction of the court. If it is an order of reinstatement, the amount of security that's required to be furnished is 24 months of remuneration. But if it's an order of only compensation, then only the amount of compensation has to be furnished as security. In this case, the employer launched review proceedings but didn't furnish any security. And whilst the review application was pending, the employee then sought to enforce the arbitration award because, of course, it hadn't been suspended. The employer then had to go on an urgent application to stay the enforcement of the arbitration award, so stop her from enforcing that award pending the outcome of the review application. And in its papers, the company did seek to be exempted from furnishing security and stated that the significant amount of security that it was required to furnish would have a serious impact on its trade and would hamper its ability to operate its business. It said that it would have a sufficient impact on its cash flow because it had to make upfront payments on its stock. But the court criticized the employer for these averments that they had made because they didn't provide any reason why they made upfront payments on stock or whether this was standard practice in the industry. It didn't give any detail as to the cash flow that was available in its bank account. There were no financial statements or management accounts to assess its previous, current, or projected cash flow challenges. And so the court in this particular case was not willing to just simply accept the employer's say-so that they were not in a position to furnish the security that they were legally obliged to provide. And they couldn't show that it would be unduly onerous and harmful to the company's business operations if it were required to furnish the security. And the court commented on other cases that had been coming to the Labour Court and stated that there was a worrying trend that has developed in the Labour Court where employers who seek to escape these arbitration awards simply review unmeritorious review applications that have no prospects of success and don't furnish the security. And as we know, litigious proceedings are quite lengthy. It can take 2 to 3 years from the time of launching a review application before you're eventually heard. And so the court has said that by default, these employers are becoming absolved from paying security because the employee didn't seek to enforce it in the period of which the review application was pending. And the courts criticized the employer for not trying to approach the employee to reach an agreement on the issue of security, and if they were going to provide security, whether it would be for the full amount as required, or if they could come to an agreement on a lower amount, or even to just seek an undertaking from the employee not to proceed with execution on the arbitration award. And here, the employer was also criticized because they had inflated and exaggerated the amount of security that they had to pay, because they said we'd have to pay 24 months security plus the back pay. And in this particular case, the LRA is quite clear. It only says that you need to pay 24 months of security in cases of reinstatement. You wouldn't necessarily have to put the back pay as security. The court also said that it's not relevant whether the employer thinks they have good prospects of success, and it also doesn't matter whether the review application is opposed or not. So those were irrelevant arguments that the employer tried to raise in this particular case. And also it commented that, we often have these big multinational businesses who are applying for review applications and saying, well, we have sufficient assets because we are a multi-million rand business. The court said that they're not just going to accept that anymore. What actually has to be shown is if you are seeking an exemption, you have to show good cause as to why you ought to be exempted from the security requirements. It gave an example of what good cause could be. For example, if an employer has 20 employees, 10 of which are dismissed for group misconduct, and 10 of them are reinstated, then it would have a material prejudice to the business for the company to put up security of 24 months for 10 individuals in that particular circumstance. So material prejudice is one of the factors that the court will take into account, but it's not necessarily decisive. It's going to look at the particular circumstances of a case, as well as considerations of equity and fairness to both the employer and the employee. And the court said, the intention of the legislature around the requirement of employers to furnish security is because it recognizes that solvency in business is not always guaranteed. A business that is profitable today, in 2 or 3 years' time, might not longer have any assets that would be sufficient if the employee was actually successful in their review, successful in opposing the review application and getting reinstated. It also wants to prevent employers from launching review applications that don't have any prospects of success and is solely aimed at looking to delay the enforcement of an arbitration award. So the court did say that it was time to seriously consider whether they should start granting punitive cost orders against employers for this kind of conduct in the Labour Court. In this particular case, although it commented on punitive cost orders, it didn't actually grant a punitive cost order against the company, but did require the company to furnish security of up to 12 months of remuneration. So it did reduce the security that was required to be furnished by half, and also required that they deliver a security bond within 30 days of the order. So the key takeaway from this case is that, unless you have good grounds for not actually furnishing security, if you've been unsuccessful at the CCMA and you want to take an arbitration award of reinstatement or compensation on review, it's quite simple to just furnish security. You'll be taking legal advice, hopefully from Bowmans anyways, and we'll assist you with that process. But there's got to be very good grounds if you're not wanting to furnish the security that's required in terms of the court rules. Thanks, Helen.
Thanks, Melissa. And I think just, I mean, that's all part of the bigger picture of the Labour Court feeling like it's turned into a review court. We saw a statistic recently, actually reviews are taking almost 3 years to be finalised, which is obviously highly problematic. I mean, we know from the new Labour Court rules that they're trying to simplify reviews and cut down on the number of reviews. So I don't think that judgment is surprising, but very important to keep in mind. I think we've only just got, so thank you to all our presenters. I think we got through that in quite a sharp and efficient manner. So hope to give you some time back in your diaries. I see just one question in the Q&A, which is regarding mutual separation. Wasn't always the stance that the courts or any tribunals shouldn't interfere when it comes to the mutual separation agreement. Your view on the prospects and appeal if the LC was challenged by the LAC. I think Nadine had to drop off for a meeting, so I'm happy to field the question. I mean, if that's in the context of whether it can be made an order of court, I think that's a technical question. Not that the the MSA is not enforceable. It is still definitely enforceable in terms of principles of contract. It just didn't meet the requirements to be related to an order of court. And in the context of the judgment in relation to voluntary retrenchment agreements, I think that is quite a controversial, quite a controversial judgment. And if we're being honest, quite a difficult one to understand. Because, and I think that's also very specific to the context of operational requirement retrenchments, where it's still related to the company's operational requirements. It's just that you're choosing to into a mutually agreed termination rather than in the context of the employer terminating the employment context, employment relationship. So I think just to that question, our takeaway is that properly executed mutually severance agreement are still completely enforceable. It's very hard to prove grounds like duress. Even material misrepresentation is a pretty difficult ground. So just to distinguish it from having it made an order of court. And I think that the in question, I think it was the WBHO case is a bit of an outlier. So still take those principles on board, but I don't think that you should be overly concerned about the enforceability of a properly executed MSA. I think that's the only question. Hope it addresses that. Thanks all. Can't believe we're saying the next time we will see you is 2025. So all the best for the rest of the year. And thanks as always for joining us. We appreciate it. Cheers all.
Thanks everyone. Bye.